So there's been a lot in the news lately about Meghan Markle's American Riviera orchard trademarks being rejected by the U.S. Patent and Trademark Office. In many cases, this is just standard. It happens. I see this a lot where especially a celebrity, when they file, if it gets rejected, the news makes it sound like it's just, some big issue. But that's sometimes just part of the course, is dealing with certain rejections or objections to get your trademark through. So let's say, take a look at one of the applications. This one is just American Riviera Orchard, standard character, meaning they're not claiming any sort of font or anything, just those words. And they filed for quite a number of things: gardening towels, gardening weeding forks, shears, string lights for decoration, lamps, stationery sets, printed cards, printed day planners, printed calendars, string bags for shopping, tote bags, pillows, candle holders, household linen, aprons, yoga mats, meditation blankets, yoga bolsters, honey butter, coffee, tea, seasonings, spices, pet food, edible pet treats, birdseed, matchboxes, match holders, retail store and online store services featuring custom and printed stationery. So they filed for quite a lot of different types of products or services. And they received a rejection, which is not really a big surprise, and I would assume that their lawyers would have known that American Riviera Orchard is geographically descriptive. So what that means is you can't claim ownership of the name of a geographic place. There is a standard, they generally say a mark is primarily geographically descriptive when the following is demonstrated. The primary significance of the mark to the purchasing public is generally known location. Although I had never heard of American Riviera before this, seems like it was. They hit there. The goods or services originate from that place identified in the mark, and the purchasing public would likely believe the goods or service originate from. My guess is some of it may originate from that place, but except for maybe some of the food items that might be grown there, I wouldn't necessarily think that consumers are going to believe that these products, that the papers, the linens, many of those things are going to come from there. But, the bar is pretty low for what an examining attorney has to show in order to make the rejection. It's now on the attorneys for Meghan Markle's company to argue that there would be no goods place association, things like that. Another way to get around this also is to do something that's called move to the Supplemental Register. And it's essentially a weaker trademark registry, which is reserved for terms that are considered descriptive, but over time can acquire distinctiveness and become stronger. So we recently had a case called Booking.com. Everyone knows Booking.com. They spent a ton of money on advertising, and it actually went up to the Supreme Court, and normally just .com names are considered like an address, so they're considered descriptive. And especially when your name is just Booking.com, there's it's a website that does bookings, so it's descriptive. However, because they acquired distinctiveness based on the millions of dollars in advertising and how so many people knew who they were and how many users they had, the Supreme Court allowed them to get a registration for that. So that's something that can happen to descriptive trademarks, is they can acquire distinctiveness and become stronger. Think of Staples. When they first opened, they're a store that sells staples and other office supplies, but after however many years, how many decades and thousands of stores and millions of dollars in advertising, everyone knows them. Similarly, Chipotle, the first day that they opened, Chipotle is an ingredient, it's descriptive. And then there's a lot of other examples for geographic, such as Brooklyn Brewery would be one that has become a strong trademark, but when it first started, it was geographically descriptive. So those are things. And here you'll see they're also requiring them to disclaim the word American Riviera, which means that other people could use the word American Riviera because it describes where it's from. So if you have a jam, which I believe was one of the things they filed for, or spices or coffee that's from there, you could say that it's from the American Riviera. And then there's just, some amendments to the description of the goods. Sometimes the examining attorneys feel it's not, like here, the wording cocktail napkins must be clarified because it's too broad and can include goods in multiple classes. So when you file, as you saw here, you file for different classes. So each one of these, class 29, class 28, is a different class, which also means you pay extra fees. You pay for each class. And sometimes when you go through prosecution, which is what it's called when you file the application and you go back and forth with the Patent and Trademark Office, they will say that certain things don't belong in this class, they belong in another class, or these words are too broad, you need to describe it better. And that's just part of the prosecution. And sometimes they'll say, you actually could add another class because of this description. So this application is something that could be fixed. Here, the biggest problem might be that these are all what we call intent to use, meaning they're not using them yet in commerce. I don't know what their plans are. I didn't look too much into that when she's supposed to actually launch. But some of these, in order to get over and into that supplemental registry, you need to have actual use of them. I have other videos that talk a lot more about intent to use versus use-based trademark applications. But just know that in the US, in order to get the registration, you have to actually use it in commerce in what you file for. So she will have to sell stationery with the name if she wants to get a registration for that. Now, sometimes people file for a lot more than they'll originally have use, and they might then just take what they have at that time. It depends upon the plans, when they're rolling different products out. But I also wanted to look at this one, because this one's slightly different because this one incorporates a logo. So it's not fully geographically descriptive, as you'll see, because it has the logo in it. So here in this one, it's just a disclaimer for descriptive wording, which is the American Riviera, just like in the prior one, we had to take that out. They don't like how they worded the description of the mark, so they want them to change that. Probably the same thing with the identification of goods, the multi-class. So here you go. This is what a disclaimer looks like. No claim is made to the exclusive right to use American Riviera for all international classes and Orchard for international class 29 and 35 apart from the mark. So if you look back at class 25, 29 and 35, that probably deals with goods that are sold or made in an orchard. So for those, 29 is jellies, jams, things that could be grown in an orchard. And then 35 is for, some of the stuff that is sold from an orchard. So for that, it's descriptive. What this means is that competitors, so no claim is made to the exclusive right to use American Riviera for all the classes, meaning for any of those goods, a competitor can potentially use American Riviera. They couldn't use American Riviera Orchard. Whereas in class 29 and 35, it might be possible because of if you're an orchard that's in the American Riviera, you're going to use that to describe your location. So it's geographically descriptive. So when we have descriptive trademarks, that's one of the things that we always describe to let clients know is that they are weaker trademarks because you probably are going to have to disclaim some of the words or go to the supplemental register, which just always means that it's weaker. It will stop someone from filing for the same exact trademark, but essentially means you have a weaker trademark. You're going to have a much harder time when you need to police it against others using that or a similar trademark. And then here, they just want them to amend the mark so that it will say the mark consists of the wording American Riviera Orchard appearing below a double-lined octagon enclosing the stylized and overlapping letters AR and incorporating decorative and looping lines. The letter A contains the stylized flower at the top of the letter. So it's essentially describing what this logo actually looks like. And you have to do that and put that in there as part of the description of the mark so that this way when examiners are searching for similar ones, you can find it at a later date if you're looking to clear. It looked like they had one other trademark which probably received all the same sort of rejections, but these are things that are fixable. It's not the end of the road for Meghan Markle's company. She could easily fix them and still get the registration. It's not the doom and gloom that the newspapers and articles like to make whenever I see these about celebrities Although, sometimes there are ones that are a lot worse, but this one appears to be something fixable. It's just something that this is a weak trademark. Just the words American Riviera Orchard to begin with are kind of weak. And I assume her lawyers advised her of that. This probably was not something that was not, this is probably something that was expected, let me say, that they would receive a rejection based on the descriptiveness, based on the geographic descriptiveness, and something that can be worked with and overcome in order to get a registration. So hope you enjoyed this. Always feel free, comments, questions. If you liked it, please thumbs up and subscribe, and feel free to reach out with any questions. Thanks.